Okay, I've started recording. So the recording of this tutorial will be uploaded on YouTube, which means it can be visible to everybody else. So if you're not happy to appear in a video, then you have to, turn off your video. Otherwise, having made that caveat, then we can proceed. So for tonight, there are 5 discussion questions which we will go through. And we're hoping that as a result of a discussion of those discussion questions, you should then be able to discuss and explain the concept of judicial review and when it is available to review administrative decisions. We should also distinguish between judicial review from merit review. Should also then be in a position to discuss and explain the requirements of justiciability in judicial review, and then identify, not that one, so skip that part on the compelling question. That was in relation to a previous assessment they had last term. Okay, so if you're happy for us to proceed, we could begin. And in the meantime, I'm going to mute the mic of everybody else, except that that setting has disappeared. Hold on. Nope, that's not the one. Okay, I might have okay, here we go. Okay, so I'm muting everyone. So if you want to say something, I think you're actually able to raise your hand, except that I forgot how it's done. But just give me a wave or try to write something in the chat box to call my attention if you wanted to say something. So let's begin by having this discussion question. So the first question I have is, should we have to read this discussion question, or should we go straight towards answering it? Because it's a long question. What is the pleasure of the group? Would you like us to go straight towards answering it, or should we just read it as a preliminary matter? Where's the chat box now? Should we read it? Should I ask somebody to read it? What do you suggest? Do we read it, or do we go straight towards answering it? Because it's a very long discussion question. Who says we should be reading it? Okay, there's very few of you here. I need you to participate. Okay. So do we read it or not? Okay, I'll ask somebody to read it anyway. For now, we might have time. I don't know if we have enough time because it's a Friday. If it's a Friday, a lot of you might want to go on dates. So that's just my problem now. Do we read this or not? We probably should. Okay, can I ask a volunteer to do the reading? The question? Volunteer? Raymond. Okay, Raymond, yes, please. Read the question for us, just for us to have a benchmark on how we go about answering the question.
Can you hear me?
I could.
Yeah, I was just having troubles with my mic because I forgot my normal mic. You want me to read the question? Question 1?
Yes, please.
Sharon Hill has decided to set up her own business providing support to disabled persons. Disability Support Workers Act Commonwealth requires that operators, owners or managers of businesses seeking to provide services to persons with disabilities must have a business licence from the Australian Department of Social Services. Such a business licence may be given only to persons who have had professional experience as a disability support worker for 5 years and who have good moral character. The Act also provides that an application for a licence must be made not later than 30 June of the same year. Sharon applied for a licence on 18 June. However, staff of the ADSS did not accept her application because their documents showing years of professional experience as a disability worker were incomplete. She returned on 27 June, Friday, to submit further documents, but these were still considered incomplete, and so her application was not accepted. On 30 June, she returned with a complete set of documents on her professional experience, but was then asked to provide further evidence relating to her good moral character. She returned the next day, or 1 July, to submit the necessary documents, but the ADSS refused to accept her application because it had been submitted after the deadline. Sharon is frustrated and angry that her application was not accepted has come to you for legal advice. Assume that recourse to the Administrative Appeals Tribunal is not available. Advise Sharon on whether judicial review is available and why.
Okay. Can I get a yes or no from everyone? So we'll give it a minute to think about what the answer should be. And after 1 minute, I'd like you to write something in the chat box. Share with the rest of the group what your answer is, whether yes, recourse to judicial review is available, and no if you think that judicial review is not available. We'll give it 1 minute, and then we can start answering that. If you're ready to give an answer, start typing in the chat box. I'm beginning to wonder where the chat box is. Doesn't seem to appear from my end. Has anyone started writing something in the chat box? Because I'm not seeing anything. Where is the chat box here? I can't see it. Yeah?
Yeah, there's stuff in the chat box.
So somebody's written something in the chat box.
Yeah.
How come I'm not able to see it? Is it because I'm sharing the screen?
What about down the bottom of your screen? There's a little chats button to click on.
No, I can't see a thing. No, nothing. From my end. No. Okay. It should be there somewhere later on. Okay. So let's just, sorry, I can't see the chat box. I might have to become more familiar with the use of Zoom. It obviously means I'm not, because I'm not seeing the chat. At any rate, would anyone care to answer that question? So there's 7 of you, which is good.
Well, my initial answer was no.
Okay.
Because at first thought, judicial reviews regarding an issue of law, and this appears more to be based on fact and some officers' interpretation of when documents were or were not submitted. It seems like the appropriate remedy would be through AATs, but so that's why I based that on my answer on that.
Thank you, Josh. Thank you. Now, the one thing I wish to point out again is that, I'd like the tutorial to be a very safe environment. Feel free to give your answers. Whether, do not be afraid to make a mistake. Okay, so let's be clear about that. And assuming that somehow, your answer might not really be correct, don't worry about that. Okay, because we're here to learn. But I'd like to give you an opportunity to actually start, answering, because if you're going to be a solicitor and you become an advocate, you need to be quite proficient in being able to communicate publicly, orally, and both in oral form and in writing. So thank you, Josh. Anyone else?
Sorry, I just logged in a little bit late. Which question are we on?
We're dealing with question 1, Anel, or is it Annalie? Annalie, yes, we're dealing with question 1, Annalie.
Question 1 on week 1, or are we on week 2?
Of week 2.
So that's the one that's labelled number 5 on Moodle, is that right?
I'm not sure, is it? Are you able to see the screen?
Yes.
Okay. So the one that's on the screen there, which says Sharon Hills decided to set up her own business. That's the question which we're trying to discuss right now.
Okay, thanks. Yeah, that's the one that's labeled number 5. Thank you.
Okay, that's good. Would anyone care to give an answer? Anyone else? Contrary opinion? Anyone else who wants to,
May I?
Who was it?
May I?
Yeah, go ahead, Annalie.
Okay. I've said that Sharon is eligible to apply for judicial review because her complaint satisfies the jurisdictional requirements of the Act. There is conduct related to making a decision.
Hold on, was it a yes or a no? I kind of missed that.
Yes.
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 Okay.
Yeah, I'd say yes because she satisfies the requirements under the Act. She does satisfy Section 6. There is conduct related to making of the decision.
Mm-hmm.
She is aggrieved by the conduct related to making the decision, again in accordance with Section 6.
Mm-hmm.
The decision is of an administrative character.
Mm-hmm.
The decision was made by a Commonwealth authority or an officer of the Commonwealth, again under that same Act.
Okay.
And not a decision by the Governor General, and it's not a decision that falls under those exclusion classes set out in Schedule 1. So for that reason, I've said that she is eligible to apply for judicial review.
Thank you. So that would be the correct answer. Now, Annalie, I'd like to ask you, when you say that judicial review is available, on what basis are you saying that? I mean, is it based on the Administrative Decisions Judicial Review Act, or are you basing it on Section 39?
No, I'm basing it on the Administrative Decisions Judicial Review Act section.
Okay.
Yeah, the Section 6.
Very good.
Because it's the conduct.
Yes.
That's my understanding. Is that right?
That's right. So the answer is correct. Now, the crucial point here is that, I mean, among others, what's crucial here is that the decision must have been made under an enactment, or the decision must have been made by a Commonwealth authority or officer of the Commonwealth. So in other words, if a decision is not made under an enactment, then it cannot be subject to judicial review under the Administrative Decision Judicial Review Act. Okay, so let's suppose that what Sharon Hills did was to ask for a copy of certain documents, and somebody in that department, in that agency, turned her down. But when the person in the agency turned her down, it wasn't on the basis of an enactment which gave that person the power to say yes or no to the request for documents, but it was probably just on the basis of a mere company policy that does not meet the definition of an enactment under the Administrative Decisions Judicial Review Act. In that case, judicial review would not have been available. Okay. Now, the other point here is that ordinarily, unlike, if we're trying to make a distinction between jurisdiction under the AAT Act and jurisdiction under the ADJR Act, in general, any decision that is made on the basis of a Commonwealth Act, for example, will fall automatically within the jurisdiction, will automatically fall within the purview of the ADJR Act. Okay, so let me repeat that. If, in general, if a decision has been made on the basis of an enactment, whatever that enactment may be, as defined in the ADJR Act, then judicial review is available under the ADJR Act. So there is no specific requirement that a law must say that decisions under this act is subject to judicial review under the ADJR Act. Is that clear? There is no need for a specific provision in a law which says that judicial review is available under the ADJR Act. The fact alone that a decision has been made under an enactment is sufficient for that decision to fall under the ADJR Act. On the other hand, if we talk about whether or not an administrative decision will fall under the jurisdiction of the Administrative Appeals Tribunal, it is necessary that a decision must have been made under an enactment, a decision must have been made in the exercise of a power conferred under an enactment, and that specific enactment provides that review is available to the AAT. So without that specific provision in an enactment saying that administrative review is available to the AAT, then the review to the AAT would have been foreclosed. Would that be clear enough? So that should have been, so that would be good. So thank you, Annalie, and thank you, Josh. So we will move on to question number 2. So again, I'll ask somebody to read this just for us to, have a, to be clear about how we proceed. Can I get a volunteer to read that specific question there? Volunteers? Jacqueline, Janet, Michael, or Cheryl? Would you care to just read that question?
Cheryl has just typed in the chat box that her audio is not working.
Ah, okay. It's really unfortunate. I've been
having problems with mine.
Yeah, I can't see the chat box. I don't know what's going on. So, okay, I'll have to figure out, what's going on here because I can't see what's going on. I can't see the chat box. Okay, would anyone care to read that question for us? Raymond, if you want, you could read it again.
The Australian newspaper reported that a federal government commission report has detailed widespread and systematic abuse of boat refugees in Australia refugee facility in Manus Island. The Australian Refugee Consortium, an Australian non-government organisation, asked the Prime Minister for Immigration and Border Protection, who commissioned the report to publish it, but he refused. The consortium has approached you for legal advice on whether it was, I can't read the word, it's covered up, grounds to apply for judicial review of the Minister's decision not to publish a report. Give your advice.
Okay. We'll give it 30 seconds to think about that question. And then after 30 seconds, can you just type in the chat box whether or not it has valid grounds, whether or not the consortium has valid grounds to apply for judicial review of the minister's decision not to publish the report. So you say yes if you think that there are valid grounds, and no if you think that there are no valid grounds for judicial review.
Hi, Manjo.
Yes.
It's nearly 7 o'clock, so I need to go in like 1 minute.
Okay, that's fine, Josh.
So,
thanks for joining us.
Yeah, sorry that I have to leave so early.
That's fine. Thank you, Josh.
All right, bye.
Bye. Okay, so I assume you've had a chance to say something in the chat box. Do we have a volunteer to answer that specific question? So would there be valid grounds to apply for judicial review?
I can start.
Yes, Annalie?
I'd say that the consortium cannot apply for a judicial review because the consortium is not aggrieved by the decision in accordance with the ADJR section 5.1, which states that a person who's aggrieved by a decision has can apply to the court for an order in review. In this case, though, that consortium is not a party and they're not aggrieved, so I said no.
Why would you say that they are not aggrieved?
They're not the refugees, and they're not on that are happening. That they're just a lobby group, I suppose. That's how I understood it.
Okay, so in this case, they don't have any rights actually that have been affected.
That's how I understood it.
Yeah.
Obviously I could be wrong, but that's how I answered the question.
Okay, so that would be correct. Okay, that would be correct. Would there be another? So the reason why the consortium won't have the ability to apply for judicial review is that it's not aggrieved. None of its right. It doesn't have any right that has been affected by the decision. That's one. Is there any other reason why judicial review might not be available? Would there be another reason?
I'm not sure if there would be some reason for it to be under privacy. I haven't looked into that.
Okay, apart from that. Okay.
You're making it sound like I should have found another reason. I'm
No,
racking my brain.
there is another reason, and this is crucial. The one thing we must remember is that, and this goes back to the representative principle of constitutional law. The judiciary would avoid making decisions if a decision actually involves trying to look into political decisions or look into policy decisions of the government. In this case, there is a political consideration that is likely considered by the Minister for Immigration and Border Protection in not publishing the report. It is a political decision. And therefore, if it involves a political decision or there are political considerations, it becomes non-justiciable. So courts will not, the courts will not intervene. They will not exercise the power of judicial review when there are political considerations involved. And this is the ruling of the court in Minister of Arts, Heritage and Environment versus Pecco Wolsend. Okay, so that's the other reason.
Great, thank you. I haven't done constitutional law yet, but I'll make a note of that. Thank you.
Okay, thank you. I actually assumed that everyone that was in this class are actually part of constitutional law right now. So it's a good thing that you told me that. Okay, so we'll move on to, so that was clear, I hope. Is it part of the, was it there in the legal memorandum assessment? So just be very careful about that. If it involves political decisions, judicial review is not available. So let's assume, okay, let's just expand this further. So let's assume that, somebody was supposed to be entitled to an allowance of, I don't know, $1,000 a month from Centrelink because of a law. And at a particular time, somehow the law was amended. And therefore that person now says, oops, my rights, I am aggrieved, my right or my entitlement to that allowance has just been removed by the government. So therefore, after trying to raise it with that specific agency, Centrelink says, no, the law has been changed. The question therefore is, can that person apply for judicial review? Because obviously the decision was made under an enactment. The person is obviously aggrieved. So, it's also an administrative decision. So the question is, would there be a point in that person applying for judicial review? And the answer should be no. Because again, the decision of whether or not to provide certain entitlements, allowances, and so on is a political decision. So it could be about somebody complaining, how come that the government did not allocate funds for a road to be constructed in my area, or for a bridge to be put up, or a railway station to be put up, or telephone lines to be established, or NBN, whatever, you know, lines to have been, the government failed to establish a budget for this. These are political questions and therefore are not justiciable, and the judiciary will not review those types of questions. Was that clear enough? Okay. So we'll move on to question 3. Oops. So can I ask somebody to read that question for us, please? Can somebody read question 3? Cheryl, can you? Or again, sorry, I can't see what's going on in the chat box. There's nothing.
Yeah, no, Cheryl says she's got no microphone. So
okay, that's fine. Jacqueline, how about you, Jacqueline? So that leaves us with Raymond and Annalie again.
I keep dropping out.
Oh, okay. Now remember, you know, even if there are only 4 of you now, there's a good chance that your classmates will look at the Zoom tutorial session. So we have to continue this discussion. Okay. There might just be 4 of you now, but actually there'll be more people who may want to look at this Zoom tutorial session. Annalie, do you mind, you know, just reading the question again for us?
That's fine, I can do that.
Okay.
The Stellar Innovations Proprietary Limited, a multi-million-dollar government contract in 2010 to build and maintain certain infrastructure projects as part of the Fast Track Infrastructure Stimulus Act 2010, Commonwealth. However, when Stellar Innovations Proprietary Limited sought to bill the federal government for a portion of the project that had been completed, the Minister for Infrastructure and Regional Development refused payment. The Minister asserted that the contractor failed to comply with the key condition of the contract. After the Minister refused to reconsider his decision to refuse payment of the contract, Stellar Innovations Proprietary Limited approached you for legal advice. The contractor wants to know if it can ask for a judicial review of the Minister's decision under the ADJR Act. Give your advice.
Okay, 30 seconds again, think about it, and when you're ready, say yes or no. So yes, judicial review is available. No, judicial review is not available in the chat box. The chat box will be uploaded in Moodle later on, but not and the video as well. But these are going to be, as far as Zoom is concerned, the video is separate from the chat box. So I will upload the text file of the chat box in Moodle, and I will provide a link of the YouTube video in Moodle as well later on. Okay, any volunteers? Would anyone want to try to give a go at this question? Anyone? Just give it a go. Yes, Raymond.
Yeah, I'm not so sure about this because the decision's yet to be made on this one, and it's
from the fact that the decision seems to have been made. The minister refused to pay.
Sorry, no, I'm getting confused. I've got reading the wrong notes. I'm sorry.
That's okay. So the question is, what? Do you think that judicial review here is available or not? Sorry, I can't see the chat box. What do you think? What is
Hello,
the
it's
crucial point here? Was that Jacqueline?
yes. Sorry,
Okay, Jacqueline, yes.
I struggled with this week. I'm still rereading the notes. It hasn't clicked for me yet. So
Okay.
Yeah.
That's fine. What's the crucial question here? So if you go by the the 5 elements that usually has to be established before judicial review is available under the Administrative Decisions Judicial Review Act. So if we tick the boxes, so we know that the person is aggrieved, obviously. What else? What else?
Can you hear me?
I could hear you. Who would that be? Would that be Janet or is that Cheryl?
So
Yes, I could hear somebody there. No, it was female. I'm
Yeah,
not
no.
sure who it was.
you're talking about the points. Applicant is aggrieved by the decision. It is an administrative decision
Yeah,
of an administrative character.
yeah,
Is it made by an officer of the Commonwealth?
yeah. Obviously,
Yes, it is.
it is. Yes.
And it's not excluded as per the schedule in the Act.
Uh-huh.
So I'm tending to think that judicial review is okay.
Okay. Somebody just dropped out. The crucial point here is that it is insufficient. Okay. We're talking of a review here under the Administrative Decisions Judicial Review Act 1977. We're not talking of Section 39 of the Judiciary Act of 1903. Okay, or we're not talking of a specific provision of the Constitution where prohibition is available in relation to decisions of Commonwealth officers. We're not talking of those specific legal remedies. We're speaking of a judicial review under the Administrative Decisions Judicial Review Act. Under that Act, the crucial point here, number one, is was the decision made under an enactment? Okay, so was the decision made under an enactment? That's the question one. Or if it wasn't a decision made under an enactment, was it a decision made by a Commonwealth officer under an enactment? So that's the question there. So going back to question one, this particular decision of the minister, so it's not sufficient, therefore, that the decision was made by a Commonwealth officer under the ADJR Act. The decision must have been made by a Commonwealth officer under an enactment. Okay, so the first question is, was this decision a decision made under an enactment? Was the decision made under the Fast Track Infrastructure Stimulus Act 2010, Commonwealth?
Can you hear me?
I could hear you.
Can you hear me?
Yes, I could.
I'm
Who's that?
trying to get in quick. It's Janet, because
Yes,
I'm
Janet.
dropping out all the time.
Yeah.
No, it wasn't made under an enactment. It was made under general law, which was contract law after a quick browse.
Yes.
That's how I saw it.
That's right. So that's good. Thank you, Janet. That's the correct answer there. Obviously, the decision here was not based on the Fast Track Infrastructure Stimulus Act. It was based on a general law of contract. So if it's based on the general law of contract, for example, it cannot be subject of judicial review under the Administrative Decisions Judicial Review Act of 1977. Okay, clear enough? Now, let's just try to go deeper a bit into this issue of a decision being of an administrative character. What exactly does that mean? That a decision is of an administrative character.
It's neither legislative nor what was the other one that you had in your notes?
Nor judicial.
You had a little diagram there, which
Yeah.
I'm just endeavouring to find. It's not Legislative, and what was the other one?
Judicial. So that's the other one.
Judicial.
Yes.
Yep.
So it's obviously not a legislative, it's not of a legislative character, and neither is it of a judicial character. Now, when we say it's not of a legislative character, what it actually means is that it's possible that an administrative agency may actually be making a decision that is kind of a legislative character, whose character is legislative. So let me repeat. When we say that a decision may actually partake of a legislative character, we're not saying that it is necessarily the legislature which is making the decision. What we're saying is that the decision is actually made by an administrative agency, but the character of the decision of the administrative agency is actually of a legislative character. And an example of a decision that is by an administrative agency that is of a legislative character would be one where it is actually something that applies to everyone, not just to a specific person. Okay, so if there is, for example, an instrument or a regulation that's passed by the Minister of Defense, for example, saying that only these specific persons can acquire a firearm, in that case, and because it is applicable to all persons, that is likely to be a decision of a legislative character and therefore not subject to judicial review under the Administrative Decisions Judicial Review Act. So are we clear about that? And that is important because in our framework of government, there are only actually three kinds of powers. It's either executive, meaning administrative, legislative, or judicial. Some would argue that the powers exercised by administrative tribunals should be considered as a fourth power, but that really hasn't been accepted because the formulation of the High Court has always been there are only three powers as recognized in the Constitution. It must be one of these three. Although to an extent, administrative tribunals are obviously part of the executive department, it attempts in a way to be judicial in the sense that it seeks to be independent. It seeks to apply principles of the rule of law. It makes sure that evidence is presented. Okay, so in this case, administrative tribunals try to be judicial, but they are not exercising judicial powers. Clear enough? Because if an administrative tribunal were exercising judicial powers, that would not be permitted under the Boilermaker case. Okay, because under the Boilermaker's case, judicial powers, as reflected in the Constitution, can only be exercised by Chapter 3 courts.
So they use the principles, but they don't use them in a judicial capacity.
They use judicial principles, yes.
Oh, sorry,
They are not exercising judicial powers.
Thank you. Yeah.
Yes, they are not exercising judicial powers. So the moment they seek to exercise judicial powers, those administrative agencies, any law that empowers an administrative tribunal with judicial powers would be struck down as being unconstitutional. So that should be clear. So we'll go to question number 4. And, this is a very long question. And then we've got another question after that. Okay. Yep, we should have time. I would again suggest that, somebody reads this question just for us to, be able to have a better sense of how to answer this. Would anyone want to volunteer to read the question for us? Volunteers?
I can't see it all.
I'm sorry?
I cannot see it all. I can only see the bottom half.
There. Would that be good? Is that better?
It's question number 8 on the Moodle site.
That's, yeah, question number 8, I think, in
Right.
the Moodle site. Yes, there. Yep.
Makepeace sends a letter to the Attorney General asking him to consider whether to allow importation of The Night of 1,000 Shames. The Attorney General's delegate decides to read a copy of the book before making up her mind about Makepeace's application. She decides that it is not a prohibited import. After waiting considerable time for a reply, a representative of Makepeace phones the Attorney General and is told that the matter is being considered by an authorised person. I think I missed a couple of paragraphs before that, wasn't there?
Yeah, because I'm trying to summarize it. It was quite long.
Okay. It's being considered by an authorised person. The authorised person is out at lunch, but an assistant says, "We're still considering your request, although we've made some progress. The good news is that we've decided that you have a good reputation and that you conduct educational activities to which the book relates. The bad news is that we suspect that you have ulterior motives for wanting to import the book. If this turns out to be potentially fatal to your application, we'll get back to you. Makepeace wants to know whether it can apply to the federal court or have the Federal Circuit Court for review of the decision that Makepeace may have ulterior motives for seeking to import the book."
Thank you. So again, can I just ask everyone to just say yes or no? So yes, do you think it's advisable, if you were the solicitor, would it be advisable for them to apply for judicial review, or no? Would you advise not to apply for judicial review? Just for 30 seconds, and then we'll try to answer that question there. And while you do that, I'm going to disappear for a few seconds. I'm just going to go to the toilet.
They don't have standing, do they? Hello?
As I see it, a decision hasn't even been made yet.
They don't have standing. The decision's yet to be made. The authorised person is out to lunch and the assistant has given the information. Yeah, so we'll wait till he gets back, but that's...
Yeah, the way I see it, the decision hasn't even been made, so what's he going to object to?
Yeah, but under the ADJR, decision must be made or proposed to be made. Under section 3. Does that come into it?
Yeah, maybe if this falls under proposed to be made, but I mean, it's basically just an assistant telling him what he thinks. He's got no authority to say such a thing, and he's got no authority to make a decision. So I think it's a bit premature to rush off and get an application at the moment, I would say.
Okay, so I was at the tail end of the discussion there. Would anyone care to give the answer?
Emily's pretty good.
Yeah, Emily, go ahead.
I don't know that I'm good. I'm just loud. I said no because a decision hasn't even been made yet. In my opinion, it seems quite premature to run off and try to ask for a judicial review of something that he's heard from an assistant who's not authorised to say anything, really.
I would actually say that because it's the process and not the decision itself, that it could possibly be one for judicial review.
Who said that? Was it Janet? Okay, interesting.
So yes.
Thank you, Janet.
Raymond, you had something else too that you were talking about?
Oh, it's questioning standing.
Yeah. Let's just point out that even if we talk about a process, it must be a process that leads to a decision. So there must still be a decision. Process alone is insufficient. So the question is there a decision? And Anneli said there is no decision. And the question is, when do we know that there is a decision or not? I thought there was a decision there somehow. What do you think? How do we know whether or not a decision exists?
When you're advised, and at the moment it's unauthorised from an assistant.
So when do we know that there is a decision?
when the authorised person gives it, you're informed.
And in this case?
Hasn't happened.
Ah, okay. That will be a good way of saying it. So there's no decision yet. Okay, fine. Let's see. What if that person said that there is a decision and the decision is no, but it is still being reviewed by the Attorney General? So would that be a decision that would be subject to judicial review?
Doesn't
I
it?
would still say no, because the person speaking is not authorised to speak. You know,
Let's
you could
assume
hear
that
this.
that person is authorized.
Oh, okay.
But why would anybody review that if they said it's still got to be reviewed by a higher person within the
I mean, if
within
you look at government agencies, you have several tiers. So it can be a decision made by a supervisor, and under the law, the supervisor may actually have the power to make that decision as the delegate. And yet there is another person above that person who is a manager who can make the decision as well. So let's assume that in this particular case, just to go deeper into the concept, let's assume that the person said, "Oh, my supervisor said that no," but it's currently being reviewed by the manager. So there is a decision. The decision is no. Is that going to be subject to judicial review under the ADJR Act?
I would have thought
I
yes.
still don't believe that the decision is final. If the person that has made the application has not received a final decision, then the process of the agency making a decision at one table, reviewing it at another meeting, making another decision a week later and reviewing it again 2 months later, that's really not for him to base anything on, because he has...
You muted yourself, Annalie. You muted yourself.
I was finished.
Oh, okay.
That's a statement question.
Yeah, thank you. If you notice, the way that Annalie has been presenting her answers,
That's how I think.
Okay. If you notice, the way that Annalie has been providing her answers, she's actually using logic and argumentation here. And they're actually quite persuasive. And she's actually correct. Annalie, you're actually correct. It is not a final decision. Right? Because it's still subject to the review. I mean, remember, we changed the facts, okay? Under the new facts that I gave, where it is being reviewed by the manager, there is no final or operative decision. And that is actually the way that the decision has been defined by the case of Australian Broadcasting Tribunal versus Bond. For there to be a decision that is reviewable under the Administrative Decisions Judicial Review Act, the decision must be final or operative, and it must be substantive. In this case, it is not final, nor is it operative. So it is not a reviewable decision because it is not an administrative decision as defined under the ADJR Act. That's one, okay? Clear about that? Would there be another reason why, assuming that it was a final or operative decision, assuming it was a final and operative decision, would there be another reason why this may not actually be reviewable under the ADJR Act? Assuming it were a final decision, would there be another reason why it may not be reviewable under the ADJR Act?
Does Makepeace have standing?
Aha. Yes. Does Makepeace have standing? Okay. How do we answer that question, whether or not Makepeace has standing?
Are they aggrieved?
Yes. Are they aggrieved or not?
No, I don't think they are.
But they're the ones asking for the importation to be made, aren't they?
Whether to allow importation, they're not saying that they want to import it. I might be a bit picky there.
So, I mean, based on the facts, they want they were hoping to actually import it. They think it's their right to import it. So let's assume that, you know, the Attorney General says, no, you cannot import it. Do they have standing or not?
It depends. If the question says asking him to consider whether to allow importation, if it's their business and they want it.
Okay, I see what you mean. So that's a good point, Raymond. So you were, you know, assuming that this wasn't theoretical, it was actually Makepeace really wanting to import, that's something else, they would have been aggrieved, they would have standing. But if this is just a theoretical question, maybe in behalf of somebody else, perhaps they wouldn't be considered aggrieved. Okay, that's fine, fair enough. Apart from that, would there be any reason why this may not be reviewable under the ADJR Act?
As I see it, there's the Attorney General makes the final decision, and whatever he decides can't be touched. He's God. So that would be one reason why it wouldn't be allowable. And the other reason is I think this would fall under that Schedule 1 exclusions. They're talking about national security.
Hold on. Okay, that's a good point. There's a special, there's a Schedule 1 in, there's a phone here. Could you just grab the phone? I'm in a class. Okay, so in the ADJR Act, there's a Schedule 1 there, which identifies, you know, what decisions under enactments cannot be reviewed. Okay, let's assume, you know, let's not talk about that. But there was a crucial point. Annually, you said that the Attorney General was God, and that his decisions could not be reviewed. Okay. What do the others think about that? Is there such a thing? That the decisions of somebody in the executive cannot be reviewed because that person is all-powerful? God is omnipotent? Is there such a thing? Is there such a thing?
Under Section 3C of the Act,
Yeah.
a decision by the Governor-General or a decision, or 3D, a decision included in any of the clauses of decisions set out in Schedule 1.
So that's fine. Thank you. That was very good, Janet. Okay. But that was the decision of the Governor-General. My conceptual question was, the bigger question I raised was, is there such a thing as a decision made by somebody who is just so powerful that it cannot be reviewed by the courts? What do you think about that? Is there such a thing? Do you think that there is actually an administrative decision made by somebody in the executive department, and because of the powers of the person, it simply is not subject to judicial review at all?
As I understand the Act, that's exactly what it says about the Governor-General.
We're talking here of the Attorney General, not the Governor-General.
Sorry.
Okay, the Governor-General is different from the Attorney General.
But the Act says Governor-General, doesn't it?
It does. But the problem here is Attorney General.
I thought the question was just in general, if there was anybody who was so powerful that they weren't up for review.
Yeah. No. Let's clarify that still further. Okay, under the ADJR Act, the powers under the ADJR Act, the decisions of the Governor General are not subject to judicial review. Fine, but the question is, would the decisions of the Governor General could the decisions of the Governor General possibly be subject of judicial review under the powers of the Constitution, provisions of the Constitution? And the answer is yes. He is a Commonwealth officer. It could also be under Section 39 of the Judiciary Act of 1903. So just to clarify, I cannot imagine of a situation where there is a Commonwealth officer, whoever that person might be, whose decision cannot be subject of judicial review. Are we clear about that? Let me repeat. I cannot conceive of a situation where a decision made by an executive or a member of, a Commonwealth officer is not subject of judicial review. Not by nature of the position, possibly because of the decision itself, because it's political, but if it's on the basis of the position itself, I don't think that there is anyone who is immune from the jurisdiction of Chapter 3 courts in terms of judicial review. So are we clear about that? So possibly under the ADJR Act, the decisions of the Governor General might not be reviewable, but certainly they could be reviewable under Section 39 of the Judiciary Act of 1903 or Chapter 3 of the Constitution, where Commonwealth officers, if there is a claim against a Commonwealth officer, or a Commonwealth officer is a party, that is subject to the jurisdiction of the courts. And it will not be possible, for example, for the legislature to enact legislation saying that somebody is simply immune from suit and not subject to the jurisdiction of the courts. I don't think the judiciary is going to allow that, because that will be to deprive or to limit the power vested by the Constitution on Chapter 3 courts. Clear enough? Questions there? None?
Is that sorry? Is that
Yes,
part
Anna.
of the checks and balances that are with the separation of powers, where none is higher or over the other, but they have got a duty to ensure that they're.
Yeah. So as far as that's part of the separation of powers, part of checks and balance of a democracy, and the ultimate arbiter of the extent of the power of the judiciary is actually the judiciary itself. The legislature cannot define what the powers of the judiciary are. It can define whatever jurisdiction might be of a federal court that the parliament may create on the basis of Section 75 of the Constitution. It may, but it cannot define the power of the High Court, for example, because that is set in the Constitution. Clear enough? So,
I feel like I'm missing half the course because I'm not doing constitutional law. Is there lecture notes or slides or anything from constitutional law that you might be able to share with us to understand what's happening here in admin law? I feel like I'm missing every other chapter.
Yeah.
Yeah.
The problem there, Annalie, with a point is that it's about 3 weeks of lecture notes. So I think the way I'm discussing it now would probably be sufficient for the purpose of having a grasp of what's going on, but we don't want to go in depth, except that, as I mentioned, I think in the previous tutorial sessions, there are points of convergence and points of divergence, convergence and divergence, in the sense that there are some common areas that tie constitutional law and administrative law. So these are in relation to separation of powers or principles of legality, principles of rule of law. But there are points of divergence as well. So, constitutional law would usually refer to at least 3 areas, and that would be the 3 branches of government, or it could be the relationship between the Commonwealth and the state, or it could be about rights and freedoms of people. Whereas if you talk about administrative law, it focuses on, at least at the federal level, it focuses on the tension between the executive and the citizens. Okay? Because I speak of the federal level because at the state level, it could be just between citizens. Like, it could be a question about consumer law, for example. But at the federal level, it's usually a tension between, or a relationship between the executive and citizens, because the rights and freedoms, rather the rights of citizens might be affected by the decisions of the executive. That's what administrative law is all about. But there are certain common areas, and that's about principles of legality, principles of rules of law, and the issue of separation of powers. But again, I'm just saying this just for you to have good idea, but we cannot go deeper because that's really more of a constitutional law. But if it's a question of can you have access to notes, I could certainly post them in Moodle. But that's a lot of reading, and it might be difficult for me to pinpoint which exactly you need to read. But I think it will be sufficient hopefully the way that I explained it. And I'm hoping that how the way I explained it was clear enough. Okay, so we could move on. It's now 7:40. We'll move on because some of you might have dates. Okay, we go to question 5. So can we call on, there are still 1, 2, 3, 4, 5. Do you mind we just finish question 5 and then we end it? Do you mind, if we go beyond the time? Okay, that's fine, good. Raymond, can we just ask you again to read question 5 for us? You're muted. Your mic is muted, Raymond. We can't hear you.
The Australian Broadcasting Tribunal and Bond, the High Court ruled at the conclusion of the Australian Broadcasting Tribunal that Mr. Bond was not a fit and proper person to hold a proper licence was not a reviewable decision under the ADJR Act. The High Court made the ruling even if the ABT conclusion on Mr. Bond's fitness was determinative of the ABT's other conclusion that licensee companies under Mr. Bond's control were consequently not fit and proper persons to hold commercial broadcasting licences. How did the High Court arrive at its ruling that the ABT's conclusion that Mr. Bond was not a fit proper person to hold a proper licence was not a reviewable decision under the ADJR Act?
Okay. Would anyone care to give an answer to that question? And I want to thank you, by the way. I mean, the 5 of you, and 6th was Josh earlier, for coming, to this session, even if it's a Friday night. Because typically on Fridays, I imagine that the Aussies are quite fond of going out, and you're quite focused in your studies to actually be here for this session. And I apologize for not being there yesterday. I was just unwell. Okay. Would anyone care to take the floor and try to answer this specific question?
If I can just quickly point to your diagram in the notes.
Yes, Janet.
Decision was interpreted in ABT versus Bond.
Uh-huh.
Decision should be final, determinative, or operative. It can be an intermediate or preliminary decision, but this must be on a substantive matter and is statutory precondition for a final determinative decision.
Okay. So applying
that's
that,
just verbatim.
Thank you. Applying those principles, what's the answer here? Why was the decision in relation to Mr. Bond not considered a reviewable decision? Why? What do you think? Okay, let's not hold each other in suspense because I'd like to have my dinner as well. Yes, Raymond.
There is some flaws in the process here, whether it was a decision made before, but I can't get my head around this one.
Okay.
But there is I think there's a flaw in the decision making process there. But
was there a flaw?
100%.
Is a problem about a flaw in the decision making process?
Yeah. Was it the decision that the reviewable decision was it a substantive one, or was there another decision made? Because it talks about more than one reason for the decision.
Because in this particular case, the basic question there was that a licensee company needed to be considered a fit and proper person to hold a commercial broadcasting license. But prior to that, for a determination to be made that a licensee company was a fit and proper person, it needed to be determined who the owners were of that licensing company. So if the owners of the licensing company were not fit and proper persons, it would mean that the licensing company was not a fit and proper person. And therefore, if that licensing company was not a fit and proper person, then it would not be entitled to a license. So if you're talking about the flow of the decision making, was there a flaw? The answer probably is no, because they had to determine whether Mr. Bond, as owner of one of the licensing companies, was a fit and proper person, because that would determine whether or not the licensing company was a fit and proper person, because the definition or the determination of whether or not the licensing company was a fit and proper person depended on whether or not the owners were fit and proper persons. In this case, there was a finding on the part of the ABT that Mr. Bond was not a fit and proper person. So that was actually a correct. In terms of the decision-making process, that was correct. It had to make the determination. But the question is, why was that finding of the ABT not considered reviewable under the ADJR Act? And the reasoning, so we'll just go straight to the answer, because we're running out of time. The reason is, actually, if the finding had been that the licensing company was not a fit and proper person, that would be considered an intermediate decision, because it's not yet final and operative. The final and operative decision is actually in relation to whether or not the license was given or not, okay? But in the decision of Australian Broadcasting Tribunal versus Bond, the court clarified that even if it is an intermediate decision can actually be sufficient to vest the possibility of judicial review. So even an intermediate decision can be. So in other words, if the decision had been that a licensing company was not a fit and proper person, in other words, there was not yet a decision that not to give it a license. If the decision alone had been that a licensing company was not a fit and proper person, meaning it was an intermediate decision, the court in that case actually said, through Chief Justice Mason, he actually said that that intermediate decision would have been subject to judicial review. Are we clear about that? But that more preliminary question of whether or not the finding that Mr. Bond was not a fit and proper person was an administrative decision that was subject of judicial review, the court said no, it was not. Because even if there was a finding that Mr. Bond was a fit and proper person, there was no determination yet of whether or not the licensing company was a fit and proper person. So there was therefore kind of a two-step process involved. So that aspect about Mr. Bond being found to be a fit and proper person was just too remote, still too distant. Okay, are we clear about that so far? So let me repeat. If the finding had been that the licensing company was not a fit and proper person, even if that was an intermediate decision, that would have been subject to judicial review. That finding, however, that Mr. Bond was not a fit and proper person was just too preliminary, because there was still a decision that had to be made whether or not the licensing company was a fit and proper person. It was just too preliminary. And so the court said, that Mason Chief Justice said, that preliminary question, that finding is not subject to judicial review. Are we clear about that? Now, why do you think was that the reasoning? What was the reason for that? Why was an aspect of, obviously there was a decision in a sense, okay? But why did the High Court say that that was not subject to judicial review? I mean, what's the whole idea about a decision being final and operative before judicial review is available under the ADJR Act? What's the logic behind it?
I would say that a lot of work goes in before a final decision is reached, and it's several steps along the way, and lots of decisions and considerations, and maybe within different government departments there might be different tables that it's got to be looked at as well. So to try to intervene in the middle of an ongoing process would not benefit anybody.
That's correct. Thank you, Annalie. Yeah, that's right. That's in fact the reasoning of the court. Wow. So we've got a budding member of the High Court here. Well done, Annalie. That's really correct. The High Court has been saying clearly that even if there's such a thing as administrative reviews, we must avoid fragmentation of the legal process. Otherwise, there will be no end to litigation. Can you imagine if a decision was made, somebody requested for more time to submit documents, and then a decision maker said no. Imagine if that was subject to judicial review, there would be no end in sight. That's why the court, as far as the court is concerned, judicial review is available only in relation to final and operative decisions, and in relation to intermediate decisions, that's possible as well. But they must really be intermediate decisions that are really determinative of the final decision. Okay, so that was the last question that we went through. Any questions or any matters that you'd like to raise before we end tonight's session? None? Okay, so thank you for your participation, and I hope you learned something tonight, and I look forward to engaging with you again next time. And have a great weekend, have a great Friday.
Thank you, everybody.
Good night, everyone.
Thank you.
Thank you.
Bye.
Good night.